Good afternoon, everybody. My name is Hussein Mahadi, and I'll be our moderator for today's session. Please kindly indicate if you can hear me. You can say that on the chat box or just reply me directly. If I'm loud and clear and audible, please let me know before I proceed. Hello, can you all hear me? Hello? Okay, thank you very much. Welcome everybody. I can see we are the mentees are joining the call, and our mentors are here too. Thank you everybody for joining today's session. Today for the data privacy and protection mentorship program for JIIPCC. Today is the first day of the second quarter of the program, and like I said earlier, my name is Hussein Mahadi, and I'm the moderator for today, and my co-moderator is Aminat. So today's topic is data collection, data processing, and data transfer. And our mentors for today are Matthew Saisi and Mr. Samuel Ungu. So quickly before we jump into the main program for the day, I'll be telling us about JIIPCC mentorship and internship program, what JIIPCC mentorship and internship program is all about. JIIPCC Mentorship and Internship Program is a quarterly program for students and young professionals across Africa. Hold on while I share my screen. JIIPCC Mentorship and Internship Program is an quarterly program for students and young professionals across Africa. Mentees are afforded opportunity to access valuable advice, training, mentorship, internship, discussion forums, and industry updates from experienced mentors. The mentorship seeks to encourage continuous training, development, and evolution in Africa and around the world. You can search for videos on YouTube, hashtag JTMIP. One of the objectives of the program is to provide easy access to guidance, training, and resource for students and young professionals, facilitate and dialogue network among experienced and less experienced practitioners to transform mentees into mentors for the future generation, and finally to facilitate further mentorship, internship, and discussion forums for the mentees. I don't know. I'm hearing myself. Someone mic is on. I don't know. Please, you can turn it off. Okay. Okay, thank you very much, everyone. Like I said earlier, we have two mentors for today, Mr. Matthew and Mr. Saisi. So quickly, I'll be reading our mentor's profile. For today, and I'll be starting with Mr. Matthew's profile. So please hold on while I share my screen. Okay. I hope you can only see me. Mr. Matthew is a Kenyan qualified lawyer with an LLM in computer and communication law. My voice is still echoing. Kindly join me in welcoming Mr. Matthew on the chat box. Thank you very much. Thank you very much. Our second mentor for today is Mr. Samuel Ungu. So Mr. Samuel Ungu is a vibrant result-driven Nigerian technology specialization in intellectual property, financial technology, and corporate commercial. Maybe to deepen his knowledge in technology law, Samuel undertook training in data protection, intellectual property, and financial technology. Some of the courses and he has acquired certified information privacy professional, right to privacy in the digital age in Africa from Center for Human Rights of University of Victoria, privacy law and data protection from University of Pennsylvania, data privacy from Northern University, general data privacy and protection regulation from University of Greeningborough. Financial foundation overview from University of Science and Technology, to digital currencies from University of Nicosia, introduction to evolution and technology concept from intellectual property from University of Pennsylvania, introduction to copyright from Pennsylvania, amongst others. Yeah. I think my voice is still quite uncomfortable for me also. Mr. Samuel has a regular invite on data protection topics by different organizations. He has spoken at ESQ Training Limited on the Nigerian data protection for Nigerian capital market, Nigeria Internet Governance Forum on data sharing and sovereignty in digital economy at IP catch-up digital economy protection and privacy at new coaching series and exploring diverse career opportunities in legal sector, data protection and privacy at ADR discourse on engaging caution for the technology sector. Samuel is a co-founder of Association of Privacy Lawyers in Africa and Privacy Hub for Africa. He is a member of stakeholders in blockchain of Nigeria, smart contract research, young lawyers mentorship and mentorship club and Nigerian bar currently an associate at Alliance Law Firm. Thank you very much for joining us. Matthew, Mr. Samuel, kindly join me in the chat box. We are so happy to have our today because the topic for today, which is data collection, data processing, and data transfer. Lastly, making an announcement to all our we'll be having a 30-minute one-on-one session with February. We encourage that you sign up. You can reach out to me or any of coordinating members to send you the link on your screen. Thank you very much. I'll be calling on my first mentor for today, Mr. Matthew, to give us an overview of the topic for today. Thank you very much.
Mr. Matthew, I don't know if Mr. Matthew is on the call. Okay, let's go. Mr. Samuel can go first, then while Mr. Matthew join the call. Mr. Samuel, please, it's over to you. Kindly hold on. I'm trying to reach out to Mr. Samuel. I can see he's on the call, but I don't know why he's not responding yet. Mr. Samuel, please, I don't know if you can hear me. Can we all hear me, please?
Yes, I can hear you, please.
Okay, just give me a moment. Okay, I think we can also take our mentee's presentation first. That can also go first before our mentor stops. So if the group is ready, you can start sharing your screen. The presenter can start now.
Hello, everyone. Good evening.
Good evening.
Okay, I'm Kamala Gotslov. I'll be presenting for Group 1, and I'll be sharing my screen right away. Okay, so our topic is basically an introduction to data protection and privacy. And okay, can we see my screen, please?
Yes, we can see your screen.
Hello?
Yes.
Okay. Yeah, we can see it too. Okay, thank you. Okay, basically data protection and privacy. We ask ourselves basically, we're at a digital age, a digital world where things are moving, and daily we're putting our information in the computers, into the internet, and most of this information we put in our personal information, and some of the softwares we get to interact in with our computers and over the internet are basically things that require personal information from us. So the question is, how then do we protect this private information or personal information that I think should be very, very keen to us, or should be very, very important to us? So we start with, what's a personal information? Personal information or personal identifiable information, majorly are those information that actually give more information or relate to an identifiable individual. Basically, in data protection and privacy, you're called a data subject. What are those info? What are those things that can actually describe someone, somebody, not a thing, someone that can be identified by something? And then we break this into two. The ones that are personal data, we have your name. My name is Gotslov Kamalo. If someone should ask Gotslov Kamalo, you know I'm the one you're talking about. If my location data, that's my address. If I should put my address somewhere, it can link to who I am, where I am. It's my personal data, because if it goes out there, I could be in trouble. My identification number. If you have your name is a personal data. It's a personal information, because if someone puts your name anywhere, it can be traced to you specifically. Your IP address, for those who use computers, IP address is actually personal information, because if you're tracking someone, you can track them through their personal information and actually get to the computer they are using. We have cookie data. I don't want to stay too much on that. Then we have sensitive personal data. Your healthcare data. Someone goes to the hospital and they bring your records of your health. These are sensitive information, because they might not fall under the actual personal data, but they are sensitive data that should also be protected and kept private from the watchful eyes of the public. Your sexual orientation, your political opinions, your race or ethnicity, these are sensitive information because if they go out to the wrong persons, you could actually be in trouble. Your biometric data, for me, I think it's still a personal data, although it's sensitive because if I put my biometrics into a machine that is linked to probably the NIMC, I would get you can get all my information. So I think my biometric data is still my personal information because science has told us that everyone has different fingerprints. Now we move on to what is data protection. Data protection are those measures, practices, policies, rules that are aimed at safeguarding sensitive information, sensitive data that you do not want unauthorized use, disclosure, access, modification, or destruction to. How is that data kept? How is it processed? How confidential is it? So let's take it in our minds that when you say data protection, rules, policies, measures, practices, how do we safeguard information? Data privacy. We all know that privacy is basically prevention of unauthorized intrusion, access, knowledge of something, just like we have trade secrets. If that's privacy, then data privacy means the protection of a personal information or data of individuals from unauthorized access as the means of protecting my data from anyone having access to it is privacy. So when I protect my data from anyone having unauthorized without my consent, that's me attaining privacy. So we'll try to differentiate the both of them, data privacy and data protection. When we say data privacy, don't forget it's access. Who has access to your data or your information? We are simply saying that data privacy refers to access, accessing it, the prevention of someone actually accessing your personal information. Then data protection, those tools, those policies that are implemented to restrict people from actually having access to your personal information. Data privacy, access. Data protection, the principles, the tools, the policies. I think there's a slight mistake here. Then data protection ensures data privacy. That's the simplest way we want to explain that. If you want to, because many people always mix them together, but there's a very thin line between the both of them. Do not forget, data protection ensures data privacy. For you to actually attain data privacy, you must have gone through some process of protecting your data. So data protection is like the mother that births data privacy. If you can actually attain data protection, you can then attain data privacy. There are laws actually that regulate data protection and privacy in the world, and we have a particular chart here. We got this on the Cordian. I'll send the link after the class, please. That talks about in the world, basically, 71% of countries have legislation for data protection and privacy. 9% of countries are drafting legislation. 15% of there are countries without any legislation on this. And then 5% are countries with no data basically on those countries. They are there, but they don't really know if they have any policy or any legislation or any or none that governs data privacy and protection. Moving forward, there are a plethora of laws that guides data privacy and policies because so many laws have things that are written in them or enshrined in them to protect our privacies, our data privacy in every facet. But the one that stands out the most that many countries are domesticating right now or adopting as theirs is the European Union General Data Protection Regulation of 2016. This is what birthed the GDPR principles for data protection. Many countries are working with this one. In Africa, we have the African Charter on the Rights and Welfare of the Child, the AU Convention on Cyber Security and Data Protection. These are now laws that are working basically in the African region. Moving forward, Other countries like Ghana has theirs, Kenya has theirs, South Africa has theirs, which means good job is being done. Then for Nigeria, Nigeria, of course, the GRONOM, the Nigerian Constitution, it provides a right to privacy. You have a right to your privacy. And then the Nigerian Data Protection Regulation of 2019, there's a bill now for 2020 that's trying to write to bring in new things that regulate data protection. We have NITDA as well, NIMSI, a whole lot of laws, but for time's sake, we can't go through all of them. But the major ones there is the Nigerian Data Protection Regulation, the Constitution, the NITDA Act. Of course, the NIMSI Act also comes into play. Key concepts. I'll just pick a few of them. Some key concepts you would always find in data protection and privacy. Personal data, we've defined that already. Information that relates to someone. We've already defined data protection and privacy. Data controller, who is the person with access? Who determines what happens to your data? Data controller, data processor, the person who actually goes through these processes on behalf of data controller. Consent, it's a very, very important part of data privacy. I have to run through this, please. I'll move quickly to principles of data protection. There are basically 7 principles by Article 5 of the GDPR that provides for data protection. Lawfulness, fairness, transparency. That principle says that when you're getting someone's data, you must do it in a lawful manner, in a fair manner, and transparent. They should be able to know what information you're getting, and it must be gotten in a lawful manner. If you get my information by misrepresentation, then you're actually infringing on my right to data protection and private protection at this point, and I can actually sue for that. Purpose limitation. The principle says when you're taking someone's data, it must be for a specific purpose, and the owner of that data must be aware of the exact purpose you are using his data for. Please, can you still hear me, please?
Yes, we can hear you loud and clear.
We can hear you.
Thank you. So the purpose must be defined. I must know what exactly you're using my information for. So if I'm going to buy pizza and you've asked for my name, you've asked for my date of birth, why are you using my date of birth? So tell me, probably you're doing a promo that if you're born, okay, if someone is born within this month, we give you extra bonus. Now that is purpose limitation. You've told me the purpose you are getting my data. So if you just ask for it, I have a right to deny you access to that information. Data minimization. This principle states holds the fact that data must be taken to its barest minimum that fits the purpose. So if you're getting my data, it should be for a particular purpose, one, and you must get the minimum data. Do not get data and say we're keeping the data for the future. We might use it in the future. No. Then you are against the principle of for you. Hello, can you hear me, please?
Yeah,
yes, we can hear you. Yes, we can hear you.
Please, thank you. So it must be used to get to the barest minimum. Do not you exceed more than you're meant to get from me in my data. So if you're getting my data for me to get pizza, just get my name, probably my house address, my phone number, and that's it. If the data you're getting does not fit the purpose you're getting it for, then get to the barest minimum of my data. We have accuracy. Data you're getting must be correct. It must be accurate. If it's not accurate, you must ensure that once you get that fact, you must correct the data or delete the data. Do not keep any inaccurate data of mine. So if you get data that is not correct, probably for a woman who was single and she's actually changed her name, at that point, it's lawful that her data must be changed to fit her new status. Storage limitation. That principle holds to not keep my data longer than necessary. If you're going to keep that, it could be for archive purpose or historic purposes, but do not keep my data longer than necessary. If you're storing my data longer than necessary, I should be aware. The moment it's no longer necessary, it needs to be deleted. Integrity and confidentiality. Can I trust that my data is confidential, is kept confidential with you, that you're taking you're handling my data with so much integrity that I would not find my data in public? Now, this is where data privacy and protection intertwined, because the confidentiality I want from you is also going to give privacy to my data. Finally, accountability. Can I hold you accountable that you're going to use every policy, every rule, or you're going to abide by legislation and regulations that protect data privacy? Data protection. Are you going to abide by those rules? Can I hold you accountable for not abiding by those rules? Once we get through these 7 principles, then that organization or data controller can hold the data of the data subject. Principles of data privacy, anonymity. How well can my data be kept anonymous? Do you put my data out there and the entire world knows I'm the one? If I've given you my data, can you protect my data so well that people do not actually have access and to know that I own that data? Notice and awareness. I must be put in the notice. I must be told that my data is being collected, is being used, or being processed. If this does not happen, you are infringing on my right to data privacy. Choice and consent. Let me know, and I must give you consent. Because you've told me, I must give consent. If I don't give consent, you have no right to access my data. Once you access my data without my consent, then you're breaching my right to privacy. Access and participation. This principle holds that I should have access to my data to correct it, to delete it in case. There are times you're working on an app, and then over time they tell you, do you want to update your information? Do you want to delete your information? I think Google Gmail does this a lot. Over time, they ask you for a new number, or the number you're using, is that the number you're using? Do you want to change numbers? Integrity and security, the same thing that I said before in data protection, that any information I'm giving to you must be held with so much integrity and secure. Enforcement and redress, the same thing as accountability. Are you going to enforce the appropriate laws and regulations that govern and protect my privacy, my data privacy? If you can actually go enforce those laws and I can seek redress whenever it is infringed upon, then that data controller is fit to handle data. In conclusion, ladies and gentlemen, we should know that our data can be used against us anywhere. Be careful the kind of personal information you put out there in the public. Before you post something, ask yourself, what would happen if this data gets leaked or gets in the hands of the wrong persons? Then ensure that you are reading every privacy policy you see in every app you want to use, or when you go to the bank, or in everything we do. You should be careful to know that they are following the principles of data protection and data privacy. That being said, thank you very much for your time, and I hope we stay data protected and also keep our data private. Have a wonderful evening. Thank you.
Thank you very much, Mr. Goslov Kamalu, for that wonderful presentation on behalf of the group. I'll be calling on Mentor to give us an overview and also comment on your presentation. I'll be calling on Mr. Samuel. Mr. Samuel, please, it's over to you now.
Good evening, everyone.
Good evening, sir.
We can't hear you, sir.
Can you hear me now?
Okay, much better. I think it's getting better.
Okay. Thank you so much, and thank you for extending this invitation to me. Before I go on to comment on the presentation that Mr. Kamalu, did I get it right?
Yes, Kamalu, that's correct.
That's it. I want to understand, because the topic I was given wasn't what was presented. So I want to know if I should just leave the topic I'm supposed to comment on and then jump on the presentation. I want to be guided.
So please come again.
The topic
your
I'm
voice
meant to
quite not very audible.
Okay, so I said that the topic I was asked to supervise and also comment on is on data collection, processing, transfer, and data minimization, which is not what was presented. So I am asking, should I overlook the topic and then come on the presentation that was just made by Mr. Kamalu? Should I forgo the topic I was given and comment on what was presented? Because they are not the same thing, so we don't conflict things.
I think you have to present your topic. Your topic, sir.
Okay, so I have to. Okay, all right. Thank you so much. Can you hear me very well?
Yes, we can hear you, sir.
Okay, so my topic is on data collection, data processing, data transfer, and data minimization. I think it's about looking at those concepts. So just to make it very simple, I won't like to confuse anyone. I will just try as much as possible to make the presentation very simple and easy to understand for everybody. So data collection is submerged under data processing. When you look at the definition of data processing under NDPR, GDPR, and some other data protection laws of various countries, you will get the clear understanding that data collection is an aspect of data processing. So referencing the definition in NDPR, since we're in Nigeria, I'll be making reference to Nigerian Data Protection Regulation and the implementation framework, and where there is need for me to make reference to GDPR, which is taken to be the global standard for data protection, I will do that. So when you look at the definition of data processing under NDPR, it says that data processing is any activity or any operation done on personal data, whether automated or non-automated. So any operation. And it went on to give an example like data collection. When you are collecting information from an individual, you are processing the person's personal data. When you are storing someone's personal data, you are processing the person's personal data. When you are transferring anything at all you do on personal data is regarded as data processing. I don't know whether it's clear. So data collection is submerged under data processing. Data processing is a concept, and data collection is an aspect. Data processing. So it comes under the umbrella of data processing. Okay, so having said that, and I said there are a lot of it, even when you are not doing anything with data, it's stored on your back-end system. It's regarded as data processing. You are processing personal information. Now, having said that, I've explained data collection and data processing. The concepts are almost the same thing, just that data collection is an aspect of data processing. So we're looking at the concept of data minimization. Data minimization is one of the principles of data or data protection all over the world. And the concept is so simple. You have to collect the personal data that you need to execute a particular project. So it is hinged on two very important factors. Concept of necessity, concept of proportionality. So the personal information you are collecting must be necessary, the purpose for which you are collecting it. And it must also be proportionate to that purpose. When you bring the concept of necessity and proportionality together. It means that the processing must be the reasonable and proportionate way or means of your people. So that if you have a less intrusive that thing, then you don't need to collect that personal information. So I want to make it a bit. Now, if you go to Jumia to purchase, let's say, iPhone from Jumia, Jumia needs to collect your phone number. They need to collect your house address. They need to collect your payment information in order to execute that. That information collected from Jumia, they are very necessary and proportionate to the execution of the contract or the transaction you are currently having with them. So if they don't have your phone number and your home address, it will be very impossible for them to deliver the product to you. If they don't process your personal and your payment information, it will be impossible for you to pay for the product, and it will also be impossible for them to, for you to purchase the product. So when you look at the information, you see that they are very important to the execution of that contract. So it meets the test of necessity and proportionality. But if Jumia goes on to ask you, what's the name of your wife? Are you Igbo, Yoruba, or Hausa? How many children do you have? You see that these later information are not necessary to the execution of that contract. They are not necessary for you, to conveniently buy the phone that you intend to purchase from them. I don't know whether it's clear. I need somebody to respond before I go on.
It's clear.
It's very clear, sir.
Yes, sir, very clear, sir.
Exactly. So when you are talking about data minimization, this is what it's all about. Another practical example I will give you, is, sorry, I'm listening. Should I continue? I thought somebody. Okay.
No,
so another instance I want to give is this. Let's say this webinar, or maybe other webinar that people want to do, maybe JIIPCC is organizing, and in the information, the Zoom information that that was sent out for people to register for this webinar, and you look at the information that are required there, they are asking you for your name. They are asking you to indicate for your phone number. They are asking you for your email address. They are asking you where you're working. They are asking you the industry. They are asking you whether you are an associate, a senior associate, a partner, and all of that. The question is, are those information necessary for you to be admitted into this webinar?
Sorry to interrupt, sir. Your voice is coming very low. I don't think. Can we all hear you loudly?
Not at all. I can barely hear him anymore.
Sir, please, you can go on.
Can you hear me? Is it better?
Yes, it's better now. Very loud and clear.
Yes, it's better now.
So where should I start? Do I have to start afresh, or I should continue from where I stopped? I can't hear you.
Okay, sir. I'm sorry, I was muted. You were telling us about the information that was collected while they were registering.
Yeah, I want to know where they stopped hearing me. So if they didn't get other explanations I did concerning data collection and processing, afresh.
I think we got other places where we're talking about the web now with regards to information that has been is being asked for more than how necessary they are.
Yeah, so I'm just trying to give further instances where the concept of data minimization is very important. Just trying to buttress on the concept of necessity and proportionality, which are the two twin, factors upon which data minimization is hinged upon. So, and I'm saying that, take for instance, this JIIPCC webinar we are having, the Google form or the Zoom form that was sent to attendees, that's you and I, to register and come for this webinar. The Google form, you are asked your name, you are asked your mother's name or your mother's maiden name, you are asked for your phone number, for your email address, whether you are a senior associate or a junior associate, whether you are a male or female, whether you are, to state the industry where you are asking, where you're working. And I'm asking, those information required in the Google form or the Zoom form, are they necessary for one to access this webinar? So these are the questions you need to ask yourself before, for you to understand the concept of data minimization. Those information, if I don't give you my mother's maiden name, if I don't give you my position in the office, if I don't give you whether I'm working in the legal industry or oil and gas, won't you still be able to carry out this webinar or to have us registered? You get? So data minimization is saying you have to get the least information needed to execute your purpose. So when you look at this webinar, the least information that everybody or anyone is expecting, to give in order to access this webinar is your name, your email, your name, your surname, and your email, just for identification purposes. I know there are instances where some will like to take statistics on the industries where people are coming from, but then where that is the case, you have to state it. But aside that, if you don't want to take statistics, all that is needed is just for you to have persons coming for this webinar register. Then the information any reasonable person is expecting you to request for is my name and my email address. So I don't know, is it clear?
It's clear, sir.
Yes, sir, it's clear.
Okay.
How about phone number, sir?
That is what I'm saying. Before you can, if you are requesting for someone's email address and phone number, you have to justify that you need the two information. What you can achieve with email address, is it possible for you not to achieve it with phone number?
Yes, sir, it depends though. WhatsApp, for example.
Exactly. So at the end of the day, that's why I said, if you listened carefully, I said that the information must be necessary and proportionate to the purpose. That purpose is very essential. So it's your purpose that determines the information that you will collect. So if, for instance, I'm a business person and I need, okay, maybe after this information, just like what I said, if I intend to carry on, maybe I want to get a statistics of where people, individuals that attended this webinar came from, maybe because it will help my business or it will help anything, then there may be need for me to ask you to state the industry where you are coming from. Do you get? So because I have a justifiable purpose for it, and the information I'm requesting is necessary for that purpose. Now, if all that is needed is just for me to gain access to this webinar, that's all, that's the purpose, just for me to gain access. You don't need my phone number. Why do you want to chat me up on WhatsApp? Do you get? I don't know whether somebody is getting me.
Yes, sir. Yes, sir. Very well.
So
Yes,
the
sir, that's
message
true.
you send to me, the message you want to send to me on WhatsApp, send it to me on email. The law says the least intrusive means of achieving that purpose. The least intrusive means of achieving that purpose. So if you think with email address, you won't be able to achieve your aim, and that it will be better achieved using phone number, then forget about email and collect phone number. Is it clear?
Yes, sir. It's clear, sir.
Okay. So that is it. I've been able to explain the concept of data collection, data processing, and data minimization. Yeah. Necessity and proportionality are the two factors of data minimization. Anywhere, anytime. The information has to be necessary, must be proportionate to the purpose for which you are collecting it. Then the last but not the least is data transfer. It's a very wide topic under GDPR. And also in Nigeria here, because of the way the provisions were drafted, a whole lot of confusions and conflicts, very, very wide for somebody to, it's not even something I can finish within an hour, but I will try as much as possible to summarize it so you understand. First of all, what is data transfer? That's the first question you ask yourself. What is data transfer? The NDPR didn't define it. The GDPR didn't define what data transfer is. However, the European Data Protection Board, in their guideline on international data transfer or cross-border transfer, defined or gave an instance of data transfer. And it means transferring or moving data from one jurisdiction to another jurisdiction. For there to be an international transfer of data or data transfer, you have to take note. One, there must be a movement of data from one entity to another entity. Very important. There must be a movement of data from one entity to another entity that is not in the same jurisdiction. Movement of data from one entity to another entity that is not in the same jurisdiction. So where there is such, then know that international transfer of data has occurred. So let's take, for instance, if Jumia transfers data to its branch office in Ghana, maybe it transfers data of people that have purchased products from Jumia in Nigeria to another branch office in Ghana, there is an international transfer of data between them. So, but if the branch office in Ghana merely collects data directly from Nigerians or data subjects who are in Nigeria, there is no international transfer of data. I don't know, is it clear? I just want to be sure that you understand.
Yes, sir. But please, if you don't mind coming again, sir, please.
So I said, for there to be an international transfer of data, there must be a movement of data or movement of data from one entity in one jurisdiction to another entity in another jurisdiction. And I am giving an example. If Jumia has a branch office in Ghana and there is a need for Jumia to transfer or to send personal information of their customers in Nigeria to their branch office in Ghana, there is international transfer of data because we have two entities. Under data protection law, we are talking about two entities. It doesn't have to be either a legal entity or legal personality. The entity doesn't necessarily have to be a legal personality. So it suffices that the branch or the entity that the data is being transferred to is a subsidiary of Jumia, but they are not in the same jurisdiction. So that is data protection. But I've said, just to make a distinction, if the branch office in Ghana, that's the Jumia branch office in Ghana, decides on its own to collect data from data subjects in Nigeria directly, that is, how do I put it? You, instead of going to the Nigerian branch to buy something, you are going to Jumia branch in Ghana, you are visiting their website. You are here in Nigeria visiting their website in Ghana to purchase something. It is not international transfer of data because there is no movement of data from an entity to another entity outside jurisdiction. But what is happening there is just data collection or processing as it is used, because the entity in Ghana is collecting data personally from the data or directly from the data subjects. Is it clear now? So that is what data transfer is all about.
Very clear.
That's what data transfer is all about. Now, I want to tell you the best practice for data transfer before I come to Nigerian provision. So under GDPR, which is regarded as the best practice, before you can transfer data to a country or another country outside EU, economic area, in GDPR, they termed it third countries. So before you transfer data from EU to third countries, that third country must either be designated as having adequate data protection law, in which case EU countries will recognize them as being adequate, or through process of adequacy decision. So the country must have adequate data protection law. And having adequate data protection law doesn't necessarily mean it has to be a photocopy or carbon copy of the data protection law of the country where the data is being originated, or EU. It means that substantially or essentially, it covers or it protects the same rights that EU General Data Protection Law, protects. It offers the same protection as GDPR. So where a country meets, there are factors to be considered: their legal system, whether the country is practicing democratic system of governance, the international treaties company have entered into regarding data protection. All of these things, their judicial system, is it corrupt, or or do they have a stable judicial system? So all of these things will be considered before arriving at adequacy decision. And once a country is recognized to have adequate data protection law, it will be regarded as having adequate data protection law, in which case their names will be listed in white list as countries that have met, the adequacy principle. So when you are transferring data to that country, you can easily transfer data to that country without any hindrance. Now, where you want to transfer personal data to a country that doesn't have adequate data protection law, for instance, Nigeria, EU hasn't recognized Nigeria to, to have had adequate data protection law. So if you are transferring data,
I didn't get the last thing you said before this one.
So I said that for a country to be recognized as having adequate data protection law, it must meet certain requirements. And I said there are a lot of factors to be considered, such as the legal system, whether it's running a democratic government or not, the stability of their judicial system, the international treaties that the country has, entered with other organizations.
I don't know. I can't hear Mr. Samuel. Can we all hear him, please? Okay.
Okay, so I'm back. I think, yeah, I'm back. Can someone hear me?
Yes, we can hear you,
Yes, sir. We
sir.
can hear you now.
Yes, sir. Yes, we can hear you, sir.
Can somebody hear me?
Yes,
We
sir.
lost
We
you
can
for
hear
a
you.
bit, so we can hear you now.
Okay, so just so simple, so we can move on. For you, the first thing is a country has to be recognized as having adequate data protection law before you can transfer personal data to the country. And I've said that there are a lot of factors to be considered before a country can be recognized as having adequate data protection law. So once you meet that, you will be recognized and your name will be, whitelisted in Nigeria, EU, to also be listed as or recognized as company having adequate data protection law. And it suffices, it's enough for you to transfer data to that country without more. Of course, there must be legal basis for you to process personal data anyway. Now, where a country does not have adequate data protection law, it has to rely, or the controller must rely on appropriate safeguards to transfer data to that country. So the appropriate safeguards includes, we have what we call the standard contractual clause. So the controller has to rely on contractual mechanisms to transfer data to that country. So, and briefly, the standard contractual clause, it has certain modules that will make the GDPR, that's the EU General Data Protection Law, to directly have effect or binding effect on either the controller or the processor you are transferring that data to other jurisdiction. For instance, what he's saying in earnest is this: if you are in EU and you are relying on standard contractual clause to transfer data to somebody in Nigeria, let's say to me, I'm running a company and you are transferring data to me as a data controller. The standard contractual clause or the module you are going to adopt, if you are transferring to a controller, if you are a controller, you are transferring to a controller. Of course, there is a model for it in EU. So that model will make me to come under the binding legal effect of GDPR, or GDPR will have a direct binding consequences on me. If I breach the terms of the contractual clause, or on the process of processing the personal information, there is non-compliance with the provisions of GDPR. The GDPR would directly apply to me, even though I am not in EU. I don't know whether it's clear. I need somebody to answer.
Not really, sir. For me personally, not really yet.
So I'm saying that the standard contractual clause, you rely on it when you want to transfer data to a country that does not have adequate data protection law. And I'm using Nigeria as a case study because Nigeria has not been recognized by EU countries as having adequate data protection law. And I'm saying that, let's take for instance, I am in Nigeria and I'm a controller. You know what a controller means. And I have somebody in EU who is a controller and who wants to transfer data to me in Nigeria. The person will adopt a model of standard contractual clause, meant for controller to controller transfer. Now, and we rely on that contractual clause to exchange to have cross-border flow of data. That's to transfer the data to me. Now, what's the standard contractual clause? The effect it has is this: it makes GDPR to directly apply to me. So if I breach personal data or there is no compliance with the provision of GDPR, I will be either penalized or sanctioned in accordance with the provision of GDPR, even though I am not in EU country. So the standard contractual clause brings the controller in the third country that do not have adequate data protection law under the provisions of General Data Protection Regulation, GDPR. Is that clear enough?
Clear, sir. Very clear, sir.
It is, sir.
Okay. So
yes, sir.
There are other ones like the binding corporate rule. The binding corporate rule is used by countries, multinational countries. Let's say KPMG, that is domiciled in several countries. So when they want to transfer data to, let's say, KPMG EU or KPMG, what's one EU country I will use? Let's say KPMG Germany wants to transfer data to KPMG Nigeria. They are going to rely on binding corporate rule, to transfer it. It's still going to have the same effect. What it's doing, in effect, is to bring these people under the provision of GDPR. So we have certification mechanisms. These are just the appropriate safeguards you can rely to transfer data to another person in another country under GDPR, which I said is being regarded as the international best practice. Now, where you cannot rely on appropriate safeguards, there is another, or the third limb or arm of it, that we call the derogations. The derogations. And this is saying that, okay, so if the third country, it doesn't have adequate data protection law, and you are not relying on appropriate safeguards, just as I listed, that's the binding corporate rule, the standard contractual clause, certification mechanism, and all of this. And there is a third one that you can rely on, and we call it derogations. And it includes getting consent from data subjects. So if you get consent of data subjects in that, you can transfer data outside EU to third country. There are also, where it is necessary for performance of contracts between you and the data subject, or between a third party in the interest of the data subjects, for exercise, investigation, and enforcement of legal rights and all of that. However, under GDPR, you do not rely on derogation on just mere choice, or maybe as okay, because I cannot, they don't have derogation. I don't want to rely on appropriate safeguards. So the easiest or the safest one is it's only relied upon as an alternative where from all the circumstances, the other two are not available. That's the only time you can rely on it. Now, coming back to Nigeria, the provision is, there is no clear-cut provision. You look at the Nigerian Data Protection Regulation, it's giving you another provisions regarding international transfer. One, there is even no definition of what international transfer of data is in Nigeria. We're just relying on the knowledge of what we have in EU to do that. But aside that, they said you can transfer if you can get what's it called, lawful basis from data subjects, and that the Attorney General and the distinct should supervise the transfer. Whereas they went under the implementation framework to say, okay, so you can, whether you are transferring, whether your name is whitelisted, the country is whitelisted or not whitelisted, you have to file certain information to the regulator before you can transfer. So there is no clear-cut information on that. But what is obtainable in practice is this: whether the country you are transferring the data to is in the Nigerian Data Protection Whitelist. That's the whitelist contains the list of countries that Nigeria has recognized to have appropriate data protection law. So whether you are transferring to that country or you are not transferring to that country, you are supposed to file certain information to the Nigerian Data Protection Bureau, detailing the country you are transferring the data, what are the security safeguards you've adopted to ensure that the data is protected, and all of those things. You have to file it to them, and not to the Attorney General. It's to the Nigerian Data Protection Bureau, before you can transfer data outside Nigeria. So, in summary, that's what's international transfer of data is all about. But I said it is more detailed. If I have all the time in the world, I will go step by step what the Nigerian law says about it, show you the conflicts in those provisions, why some of them are not right, the best practice, and then what is obtainable in practice. But I just have to come in because we've spent a whole lot of time on this, and I want to comment on the presentation that was made by Mr. Kamil. So, in summary, that is what international transfer of personal data is all about, and that comes to the end of my presentation on data collection, data processing, and data minimization and data transfer. So I'll just give a few minutes for them to ask questions before I comment on the presentation made by Mr. Kamalu. Yeah, thank you.
All right, thank you very much, Mr. Samuel. I think anyone that has a question can raise your hand, and I'll call on you to ask your question accordingly. Thank you very much as you do so. While you are doing that, I think we'll encourage everyone to put on their videos, to take screenshots of every session. The reason is we usually post some take home that we had from the class on our social media platforms, right? And also tag our mentor for today. We also tag JIIPCC, so we just attach the pictures that we have from the session. So I'm encouraging all the mentees to put on their videos while I take some screenshot, and you can also take some from your end. And also raise your hand while asking your questions, so I will call on you to ask. If you have any question regarding all the presentation from Mr. Samuel, please, you can ask now. Thank you very much. I can see those that are on their videos. Okay. It's just going to take maybe 30 seconds and I'll be done. All right, thank you very much. Please, you can smile for the camera. Thank you. All right, thank you very much. Okay, I can see no one is asking any question yet. I think we also have some questions from the first presentation, and I would like to also make some clarity here. I think the topic that was presented by Goslov is introduction to data protection and privacy, the definitions, the laws, regulation, and some key concepts. And what our mentor took us today is data collection, processing, transfer, and data minimization. We are meant to have two groups for today's session, group 1 and group 2. And our presenter for today, that's the mentee, Mr. Goslov, is from 1. Sadly, group 2, we are unable to come up with their presentation. That's why we didn't have any presentation from that topic. So thank you very much, Mr. Samuel. As he already, I wanted to ask him, I wanted to appeal to him to make a summary or just also comment on Mr. Goslov, but he already said he's going to do so. Thank you very much, sir. And I think we have some questions on Mr. Goslov's presentation. I don't know if you would be able to take that. Those are questions that we sent before the session also. So you just indicate. Thank you very much, sir.
Okay, thank you so much. Yeah. Okay, so on the presentation made by Mr. Kamal, some of the things I noted a few things. One, I saw where it was talking about sensitive personal data or special category of data, and I saw something like general data. I don't know whether that is a typo. Maybe you wanted to say genetic data, but there is nothing like general data.
Yeah, yes, sorry, it was genetic data, so not general data. Sorry.
Okay, so that's fine. But then it's also important to point out that in Nigeria, or under the Nigerian Data Protection Regulation, genetic data is not regarded as sensitive personal data. Same thing applies to biometric data. The Nigerian Data Protection Regulation listed data that would be regarded as sensitive personal data under the NDPR. When you go there, you check it. I'm aware that in the implementation framework, one or few other data was added. But if you check paragraph 2 of that implementation framework, it says that the implementation framework is here to clarify the NDPR and not to override the NDPR. So where NDPR has not specifically provided for a particular thing or has not included certain data to be among the sensitive data in the list that was made, the implementation framework cannot introduce a new concept entirely to it. Anyway, that's is more jurisprudential than what we are doing today. But that's just have it at the back of your mind. So you can check the Nigerian Data Protection Regulation 2019 for more clarification. So you can see the list of, However, under GDPR, both genetic and biometric data are regarded as sensitive personal data. In GDPR, they call it special categories of data. So that is. Then I also saw that there is a place you said that the essence of data protection is to protect the availability, the confidentiality, availability, and integrity of data. No, that's not correct. That is the essence of cybersecurity. The essence of cybersecurity is to ensure confidentiality, integrity, and availability of data. That's the hallmark of cybersecurity. Now, data protection is wider than that. Do you get? It doesn't necessarily, yeah, data protection is wider than that. It's wider than the scope of confidentiality, availability, and integrity of data protecting. So what I mean is, even where there is no data breach, there can be non-compliance with data protection law, which will lead to fine. So data breach is just a concept in data protection law. And is that data breach that brings, and of course, the principle of confidentiality that brings cybersecurity into data. So cybersecurity is just an aspect of data protection. So where the confidentiality, availability, or integrity of data is compromised, you have data breach. But where you do not comply with lawful basis, I'm giving you an instance. You are supposed to tell, so the law says, if we are to follow the principle of transparency, lawfulness, transparency, and fairness, you're supposed to tell data subject, these are the information I'm collecting. This is what I do with it. This is my legal justification for doing it. These are the security measures I have in place to do that. If you don't do that, if you don't communicate that to data subject, what we call, in privacy notice, some persons call it privacy policy. But if you don't do that, if you don't tell data subjects that through the privacy notice, you have not complied with data protection law, or you have, breached. I don't like using that breach because it's very technical. You have not complied with the provision of data protection law. You have defaulted in the principle of transparency and lawfulness. So that is not breach because there is no breach of personal data there. But you have breached the provision of law on data protection law. I don't know. Are you getting it?
Yes, sir.
Now, when you are talking about breach, data breach, you are talking about an accidental or negligent act leading to the disclosure, unavailability, loss, alteration, modification, any of this of personal data. And when you look at it, you see that it encompasses confidentiality, availability, and integrity. So confidentiality says you should not disclose this data to a third party. Do you get? So where you disclose it to a third party, it becomes data breach. Availability means that the data has to be available. I must access it at all points in time when I want to. So if hackers attack your database and logs you out or logs a company, that you cannot recover that data from the hackers or attackers, then you have breached, compromised the principle of availability. The same as well as confidentiality, because not only have a third party, have access to the data, he has also made that data unavailable to data subjects. Now, the integrity comes in where someone gains access to the data and decides to modify it. So, maybe I wrote my name as Samuel and a third party goes there and puts Camelo. Can you see it? So somebody has modified what is there. So the data is no longer accurate. So cybersecurity talks about confidentiality, availability, and integrity of data, but it's an aspect of data protection because data protection is related to it. But that is not to say that the essence of data protection is to guarantee confidentiality, availability, and integrity of data. No, that's not the essence or it is wider. So the essence of data protection is to ensure that controllers who have in their custody the personal data of data subject complies with the principles of data protection law, all the principles of data protection law. We have 6 of them. And out of that 6, is only one that talks about security. And that's the principle of integrity and confidentiality. I mean, the principle of confidentiality. So, is it clear? Okay, so, Kamel, okay. Yeah. What was your question?
Okay, sir. Because it's almost sounding as though you're alienating confidentiality altogether from data protection and also bringing it back into data protection. So when you say it's not, when you say data protection is a wider scope than even data security to an extent, so that means, are we not saying then that cybersecurity is actually a longer arm of data protection? And if one of the principles of data protection has confidentiality, and that particular confidentiality is actually achieved through cybersecurity, that means the principle of confidentiality and integrity is still upheld under data protection and doesn't really needs to be completely removed from data protection.
You are not understanding me. I didn't say they are not upheld under data protection. In your presentation, you said the essence of data protection law. You know what it means to say that something is the essence of? That's the main objective of data protection law, is to guarantee confidentiality, availability, and integrity of data. And I'm saying that that is not the main objective of data protection law. That even though data protection law ensures confidentiality, availability, and integrity of data, of personal data, it goes beyond that to ensure the protection of other things that are not related to confidentiality, availability, and integrity of data. Is it clearer now?
It's clear, but I think probably you confused what I was saying then, sir, because what we're saying is really, really clear. But we're talking about the principles, and this is one of the principles there. Of course, it's not the major essence of it, but looking at the principles of what data protection by the GDPR is trying to actually protect, we can also agree that confidentiality and integrity is also a part of, let's say, the process of what data protection is also trying to achieve. Can't we agree on that, sir?
Of course, we've never disagreed on that. I'm just saying, when you say, it's a different thing to say that something is submerged under something or under another thing, than to say that, okay, the main point of this is to, it's a different thing to say that, okay, I'm speaking to everybody. Or it's another thing to say that I am focusing on you. They're not the same thing. You get? But when I'm speaking to everybody here, I'm also focusing on you. You get? But when I'm speaking to you, I'm ruling out every other person here. I don't know whether you got this logic.
Okay, sir. So I think I'll withdraw the statement main essence then. It's not the main essence. I'll withdraw that statement from it.
That's the emphasis I want to make.
So I apply to the courts to withdraw that.
Okay. So yeah, then I can see that you didn't understand the difference between privacy or right to privacy, data privacy, and data protection. Going by your definition, yeah, it's not clear to you. So, right to privacy or privacy is a different concept from data protection and data privacy. So when you're talking about right to privacy, you are more like authors, scholars, and thought leaders. They don't like to define this because there is no one way of getting it appropriately. But I will just tell you, what I have. When you're talking about privacy, you are more like talking about right to be left alone. And in Nigeria, it's provided under Section 37, right to privacy. Don't come to my house if I do not give you permission. When I'm talking, you don't have to eavesdrop. So right to be left alone Do you get? So it doesn't necessarily have to do with data, personal data. When you're talking about privacy in its form. So privacy is very wide. Do you get? Now, in your presentation, I think you misplaced privacy to data privacy and data protection. Now, data protection and data privacy fall under an aspect of privacy known as information or informational privacy. So when you're talking about informational privacy, that's when you're bringing in the concept of personal data. Now, I want to speak a bit on data privacy and data protection. So the thought leaders, authors haven't agreed on that concept, whether that concept signifies the same thing or not. So some persons prefer to call data protection data privacy. I mean, personal data, things that deal with personal data, data privacy. Others prefer to call it data protection. I'll give you two reasons, why it is so. People from European data protection, people from European Union calls it data protection. And the reason is this. In the European Charter of Fundamental Human Rights, Section 7 provides for rights to privacy. And Section 8 provides specifically for rights to data protection. Do you get? So, making the two rights different or separating it from each other. So when you're talking about data protection in EU, it's a separate fundamental human rights, different from right to privacy under EU. And the same has followed through down to Convention 108, and even 108 plus. But then in other countries, such as maybe US and country like ours, there is no separate provision for data protection law. What the Constitution provided for or provides for is right to privacy. Now, when right to privacy was, founded, or when people were, when it was entrenched in those various laws, we've not had this digital world as we have it now. And I'm using Nigeria as an example. So in order to accommodate this, our digital space or digital home, the court in their wise wisdom has decided to expand the scope of right to privacy to accommodate informational privacy. So when you see people talking about data privacy, data protection, they are talking about the same thing. They are referring to personal data, things that has to do with it, which is quite different from right to privacy. So it's a conceptual issue. And even up till now, scholars haven't agreed on the appropriate term, whether it should be termed data privacy or it should be data protection. But I've told you, because in EU, their charter, the Fundamental Rights Charter, the EU Charter on Fundamental Rights, made a separate right for data protection right then, and also provided a separate right to privacy. They do not have to conjoin the two terminologies to achieve their aim, which is what most other countries are trying to do, trying to bring data protection law under right to privacy. And because of that, they are now calling it data privacy. You get? So, but I think, I'm going to give you my opinion. I think that the best term for it is data protection. Data protection should be the appropriate concept for it, and shouldn't be data privacy. To even start, data cannot enjoy privacy. We are in a digital world, and the law encourages sharing of data. But with a caveat that even though you are going to share data, you should ensure its protection. So you can't be talking about privacy of something that has to be shared. You should be talking about how it should be protected. But that's my opinion. So, but this is still, a highly debated issue all over the world. Now, in Nigeria, the court expanded the provision of Section 37 in several cases. The latest being the case of Digital Rights Lawyers Initiative and National Identity Management Commission. Court says that Section 37 is wide enough. That phrase, privacy of citizens, is wide enough to accommodate data protection law, or to accommodate the data protection rights of data subjects. So whether you call it data privacy, data protection, you shouldn't even be much more bothered about it. You should be bothered about understanding the principles, how this works. So, but why I brought it up is that data privacy, data protection are not the same thing as right to privacy. So when you're talking about right to privacy, data doesn't necessarily have to be involved. And I'll give you an instance. In the case of Ibrahim and Nigerian army, Ibrahim cohabited with a junior's wife, and he was court-martialed. And then court-martial found him guilty and dismissed him from army. And then he approached a court to determine whether the decision of court-martial was right. And after all their argument, the court held that the act or the attitude of Ibrahim in cohabiting with a fellow junior's wife was an invasion of the junior's privacy to whom? I don't know whether you're getting me. It was an invasion of his privacy. So there was somebody didn't possess personal data, but someone's home was invaded. Someone went there, slept with someone's wife. So court held that the junior's home was invaded. So the privacy of his home was violated. So, and then we talk about privacy. Now, nothing at all brings data protection, personal data in this, because no data was processed. I don't know whether you are getting what I'm saying. So, but when you're talking about data protection, it has to relate to personal data, information that identifies a living person, either directly or indirectly. So, and there are some things in data protection, some acts that you will do that will not even amount to privacy. But when you fail to do it, you will be penalized. For instance, not relying on lawful basis does not on its own invade right to privacy. But when you don't do it, you've breached data protection, the principle of lawfulness. Anyway, it's so wide. I don't want to go deep, so I don't have to confuse people more. But that's it. You have to understand that right to privacy is different from data privacy, data protection. So the concept of data privacy and data protection are still very much debated. And at the end of the day, it points to one thing: informational privacy, which is not the same thing with right to privacy. please. Then you talked about principles of data protection. I don't know where you got that. Or saying concept, notice. No, that's not principles of data protection. If you're talking about principles of data protection, there are 6: lawfulness, transparency.
Sorry, sir. I think if you had checked the slide, you'd have seen the one you're calling now. I don't know if you got the slide on time. Those ones were actually there. I'm talking about where you see consent was regards to privacy, and we're talking about other principles that can actually work with privacy. But the GDPR principles you're calling now are in the slide. I think that was the first one before you go to the one that had
list
consent.
those ones and then tell me privacy, principles of data privacy? What's your justification for it?
Okay, basically, if you go to, so we had to do various researches for this particular topic, and you get lots of principles. And one of this we went through, I talked about privacy and some other principles outside the GDPR that is basically looking at data protection. That when we say let's distinguish it, because we still hold that data privacy and protection have quite a distinguishing, and looking at some principles that can actually hold forth for data privacy. Might not really be so much in data protection, although they are mostly intertwined.
I don't even get what you're saying anyway. But then, okay, so this is my opinion about it. Now, when you're doing a research about something, first of all, you check the global standard on that, and then you check the provision of your law or the law of your jurisdiction. That is what will form, the basis of whatever argument, whatever thing you're going to say. The global standard for privacy principles are not what is there. You said you stated it in your slide. I didn't go through the slide. It's through your presentation that I jotted this down. So you should stick to that global principle. Then, if by any bit of imagination, the law in your jurisdiction added extra or didn't even comply with that, then you can say, okay, but in Nigeria, this was included or this wasn't included, because you are doing this because you want to learn. So you wouldn't like to confuse yourself. So if you go to, for instance, if in Ghana they are talking about openness, that's for Ghana. So it doesn't apply to Nigeria, and it's not even recognized globally. Anyway, when you're talking about openness, you are still referring to transparency. But it's good to know this. If they say principles of data protection, you should talk about lawfulness, transparency, fairness, data minimization, people's limitation, and just call the name the way it is. So it will show somebody that you know what you're saying, So yeah, so that's all for me. So for the questions, I don't know, please can you refresh the questions so I will answer them. The question you said.
Thank you very much, Mr. Samuel, for the comment on the presentation. I think we have 4 questions here, and I don't know if we still have any live questions. The live questions can still come in before I ask the question. We'll just try and be brief. Okay, the first question is what is how effective is the current data protection measures in preventing data breaches?
Is it in Nigeria or in the whole world? The question has to be specific.
Okay, it was not specific on this question, but we cover
okay,
Africa.
So if you are talking about, okay, so in Nigeria, we don't have strong data protection. In fact, we don't have data protection law. What we have is a subsidiary legislation on that matter. And to a greater extent, it has hampered the development of the ecosystem. And it hasn't, to a greater extent, ensured compliance and enforcement of data protection rights in Nigeria. So we don't have great law guiding data protection law in Nigeria. But we are very optimistic. We have data protection bill right before the National Assembly, and we are praying and hoping that the president passes it, sent it before he leaves the office as the president on May 29th. So that is it. Globally, we have some legislations that are very effective, like general data protection regulation is very effective and is even extraterritorial. It's possible for you to be in Nigeria, a controller to be in Nigeria, but based on your processing activities, you are under GDPR, or GDPR will have implication on you. The same thing applies to, that has been the case with US. You see them penalizing Meta, Google, Amazon, finding them 800 million euros and all of that. Yeah, so GDPR has been very, very effective. So, but just as you know, there cannot be 100% data protection in the world. There can't be 100% data protection in the world. Yeah. So no legislation will give you 100% protection. I don't know if justice.
Thank you very much. We got that. I'll be asking the next question. What are the roles of artificial intelligence in data protection and privacy? Maybe yes.
Well, it's AI has a lot of data protection implications. One from the large collection of data from which the AI is trained to act the way it is acting, or it should, to respond to the way it is responding. So many issues could arise, such as, lack of transparency. You are collecting large quantity of data to train AI. Where are you collecting it from? Have you complied with what the law says? Did you inform data subjects about the collection that you are using their data? There could also be issue of data accuracy. I read somewhere somebody asked GPT, to say something about him. He asked GPT about himself, and ChatGPT said that he died long time ago. Yeah, it's a serious. He told him that he died long time ago. That response came, from the data that ChatGPT was trained. So you are talking about data accuracy. So that information is inaccurate because the person he's speaking to is still alive. So the AI AI, has a lot of issues with data transparency, lawfulness, data minimization, data accuracy, and even data storage. So there are conflicts here and there. And if you look at what is happening now, AI is now taking a center stage in data protection ecosystem. I read yesterday that German data protection regulator, is investigating ChatGPT, a generative AI. A few weeks ago, the Italian Data Protection Authority, the Italian Data Protection Authority asked OpenAI, to withdraw ChatGPT from Italian jurisdiction because it doesn't comply with data protection law. So you see a lot of persons investigating it. I think UK too, are carrying out investigation, and laws are now coming up, to say, okay, if you must deploy this, it must be this way. So that is it. So AI has a whole lot of implications on data protection, data protection and personal data.
Okay. Thank you very much, sir. I think for the sake of time, we'll be taking one more question before we end this session for today. What are the impacts of data protection and privacy regulations on global business operations?
Very, 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 it's a very straight question, and I'll just answer it. Data protection, the whole world is tilting towards digital economy. The whole world is tilting towards digital economy. And data, personal data specifically, is the lifeblood of digital economy. So you can't even deal without it. You can't do without it. So companies must cultivate the habit of complying with data protection, building strong data governance. So if you can show, if data subjects can, if you can sustain data subjects' trust, then it's going to scale your business. Is also going to increase the share value and asset value of a company, can give them bragging rights and also competitive advantage over their competitors. On the other hand, failure to comply with data protection law will cripple a company's business. So it can lead to loss of reputation, because when you hear that maybe one e-commerce platform has suffered data attack, you wouldn't like to go down and buy something again and drop your, and give away your payment information. Let's say I am running a platform where I sell phone, and then you get to learn that I was attacked, or hackers attacked my platform, and they collected all the information there. Will you like to come and buy something, and then I'll tell you to put your payment information? Will you accept to put it? These things are very, very practical. You won't. So it leads to loss of reputation, diminution of customers' trust. It also leads to fine, heavy one. I know companies have been fined 400 million euros, 800 million euros, and it could even lead to a stage where you can be asked to stop carrying out your transaction, to cease operating, or to cease operation, so to speak. So yeah, it has a huge implication on global trade. Thank you.
All right, thank you very much, sir. I think we have a question on the chat box from Grace Aku. Thank you, sir, for the presentation. My question is on data transfer. When you spoke on the international data transfer, it only related to personal. So what if the data that is being transferred to another country is not personal?
In fact, yeah, don't worry. Yeah, sure. Thank you so much. So to answer that question, data protection law only governs personal data and not other data. Personal data is not the only data. There are other kinds of data, but when it does not identify a living person, either directly or indirectly, it doesn't come under the protection of data protection law. Maybe other law can take care of it. So, for instance, company information, name of a company, no one cares. Data protection law doesn't have implication on it. But of course, somebody can bring an action in intellectual property against you if you misuse their company name, because that is their brand. But data protection law has nothing to do. If the information is not personal data, data protection law doesn't apply. So if data protection law doesn't apply, international transfer of data doesn't even have to be there at first place. So yeah, that is it.
All right, thank you very much, sir. I think with this, we've come to the end of the program for today. It's almost 2 hours, and I also apologize for not being able to, on behalf of our other mentor, Mr. Matthew Saisi, he reached out that he's in another meeting, so he won't be able to join us for today. Thank you very much, Group 1, for the presentation, all the group members that did the research and came together to make sure the presentation was available. And to group 2 members, please, you can do better. We don't accept that incompetence here. So try and see how you can talk to yourself and get your PowerPoint presentation ready for next week. With this, thank you very much once more. A very big thank you, Mr. Samuel, for mentoring us on the topic today. I believe we all learned a thing or two. I hope we also take down some of the things we learned for our social media posts. Thank you very much once more. I don't know if Mr. Joe is still on the call with us. Can just give us maybe a closing remark, and that will be the end for today. Mr. Joe, if he's on the call, or if he isn't, we can just close for today. Thank you very much, everyone, and have a wonderful week ahead. Bye bye.